would like to give Andrew and Richard a minute, half minute each to just basically give a quick sum up of some key takeaways. So Andrew, let's start with you.
Sure, thanks. I'll be brief. I think what we've seen in the data is compelling. So the number one, that it seems like there's a small uptick in parties not dancing. I will say that what I don't want to imply is that that's a one size fits all situation. I think all the different factors that Richard just stated, I think, are true and are unique to each situation, but it does seem like there's an uptick. And one of those reasons is what Richard said was interesting in terms just of timing. That's another additional thing. You don't engage in the dance. You can try to get some resolution, maybe settlement or something earlier. In terms of patents, again, what we are seeing is more patents being asserted and on lists and asserted, and it really behooves you to, as early as possible, put together a comprehensive plan on either side of whether you're applicant or a sponsor as to how to deal with, understand your portfolio, understand how people might challenge your portfolio, and think through ahead of time what actions you'd take in terms of and what your position would be given various maneuvers from the other side during the dance.
Thank you. Key takeaways from Richard Mortimer. Take a minute, please, sir.
Great. No, thank you. I think some of the key takeaways is one, to keep in mind through the IP litigation process of what the incentives are in terms of getting on the market for the biosimilar and the biologics, what's at stake, the brand biologics, what's at stake there. I think, as Andrew mentioned, the complexity of the patent portfolio raises an interesting decision process within the patent dance case in terms of whether the patent dance is helpful for clarifying that, or whether the perception is that the brand biologic is going to, whatever patents come out of the patent dance, the brand biologic is still going to assert additional patents later in the process, and whether the patent dance is helpful in facilitating getting through that, or actually bogs down the process and causes sort of a longer negotiation. So I think those are things I would keep in mind, and then also that the participants here are really coming at it from a unique perspective. That you have participants who are in some cases a defendant on some of these cases, and on other cases they're serving as the plaintiff, and how that balance of sort of wearing two hats, which is something I think we haven't really seen that much of in past IP litigation in pharma, where on the generic side, it's typically you have just a generic company or a brand company, and they're traditionally one and the same, playing one role or the other. Here you have companies playing both roles, and does that change the way in which they approach and think about both the IP litigation and the way in which they approach and think about competing on the market after entry?